Hello everyone, my name is Nicholas. Thank you, Stuart. Yes, as you said, I have a background in software, so a lot of my patent drafting fills the gap of software and business methods. And so what we're discussing today is the unilateral changes that have happened in IP Australia in relation to business methods. Okay, so as I go through my slides are slightly different, so follow the numbers at the top of your handouts. And you'll follow what I'm saying. Okay. So recently it's become harder to patent business methods in Australia. We've seen a large number of business method patents that have been refused. Australia used to be a safe haven for business methods. Attorneys routinely used to file these nice broad method claims, and one or two of them would be refused for not being patentable. And it was a simple matter of referring to the specification, finding support for a computer, and simply putting the words computer implemented in the preamble of the claim. Now that was usually enough to convince the examiner, but that's changed. Okay, so we've seen a clear agenda by IP Australia, which is strange because there's been no change in the law. The last case dealing with this issue was the Grant case in 2006. So it's a unilateral change, and well, who's been affected? Well, there are some legitimate cases, patents that shouldn't be granted. We've got tech giants like Google, right? A lot of their claims are relating to a method of serving an advertisement. That network netted them $11 billion last year. So is that something that should be patentable or not? We've got gaming systems, are those business methods? We've got social media, checking in, social graphs, etc. I mean, just look at the IPO of Facebook. Now, this is where the money is these days. Okay, so we're talking about business methods and software interchangeably because they often bleed into each other. While they're distinct beasts, often a business method is step A, B, C, and software is step A, B, C. Okay, so either IP Australia is wrong in previously accepting these business methods, or they're wrong in rejecting them now. And one of the cases that they've rejected has been appealed to the federal court, so that's the Research Affiliates case. So that's been heard in November of this year. So hopefully we'll get a clear answer, some clarity into what is and what isn't patentable. But for the time being, there's a certain amount of uncertainty. If a client comes into our office and says, is this patentable? It's really hard to advise them because at the end of the day, sometimes it's a subjective opinion of the examiner that prevails, and some software or computer implemented methods are refused as being business methods. So what we tell our clients is, look, if this is a commercially valuable project to you, file despite the risk, because it may be 5 years before your application hits an examiner's desk, which is a lifetime for software. And by then we may have some clarity in the law as to what is and what isn't patentable. So just to highlight the uncertainty, just going to put a little test up. We're going to put up 3 claims, and you as IP professionals should tell me whether these are patentable or not. You'll see you've got a score sheet. So for each of the 3 claims, just tick yes or no. Is it patentable? All right. So the first claim, you should be thinking iSelect or Choosy. This is an online aggregation method. It's got 3 steps. So you receive a loan application across the net. You select lenders, for example, Commonwealth Bank, NAB, Westpac. You send the loan applications to the lenders. You receive responses from the lenders, and you display the response to the applicant. Okay. Now, is this something that's patentable? There are 5 questions you should ask yourself when looking at this claim. Can you patent a business method in Australia? Okay, so that begs the second question. What is a business method? Is a business method that something has no physical embodiment? Is it something that's done purely by humans? Is it something that has no useful results? The third question is, does it really matter whether you can classify something as a business method or not? Fourth question, what does the Patents Act say? Does the Patents Act say you can't patent business methods? And lastly, what do the courts say? What is the test? Isn't the test whether the claim results in something useful? So is displaying the lender responses to the customer something useful? Okay, so mark patentable or not patentable. Here we have the second of 3 claims. So this is in keeping with the financial method examples. This has got 3 steps: giving someone a credit card and a home loan, keeping tracks of the credit card points, and allocating the points of the credit card against the home loan. Okay, is this something that's patentable? And lastly, we have another financial example. So this is talking about weighting a portfolio of assets, compiling a passive investment portfolio. So you're selecting some data about assets, you create an index, and you weight them in a certain manner. All right, so how did you score? Did anyone say they were all patentable? Hands up, anyone? No? Did anyone say none of them were patentable? No, none of them patentable? Who said that the first two were patentable and the last one wasn't? No one. Oh, one. We've got one person who's correct. Okay, so these are the results. And so you can see that the first two are sealed patents, and the last one has been refused. Okay, so I'll let you know a little secret. It's very easy to tell whether or not something is patentable, but unfortunately, the way things are in Australia at the moment is it doesn't involve looking at the claims. It involves looking at the examination date. So we look at the first two, 2008, 2006. All right, but sometime in between, it's no longer possible to patent business methods. So 2010, at some point in time, IP Australia drew a red line and said, right, enough is enough, no more business methods. So I can hear those patentees sigh in relief, saying, oh, thank goodness we got our business method patent accepted before they changed their mind. Well, this isn't necessarily the case. We've seen the Mile opposition case where the sole ground in the opposition was for lack of novelty, but the hearing officer of his own accord chimed in and said, look, this is something that isn't patentable. So even if you've had a patent accepted, it could still be refused or revoked by the Australian Patent Office down the line. So what happened? So here we've got a timeline that puts things into perspective. We've got the green lines, which are the court decisions, which are the authority, and we've got the red lines, which are the Australian Patent Office decisions by the Commission's delegates. Okay, so just considering now the green lines, really in modern times, the watershed case is the NRDC case, which is number 1 back in 1959. So that was a method of spraying crops to result in a weed-free tract of land. Okay, then we have in number 2 is CCOM, then Welcome Real Time, and then the last authority was the Grant vs. Commission of Patents in 2006. So on the right we have the Australian Patent Office decisions. We refer to this as the Great Business Method Smackdown. There's 11 cases, starting with the Invention Pathways case in July 2010, which is really when all this trouble started. Now, case number 3 is the Research Affiliates case. That's the one that's been appealed to the federal court. And the claim of the Research Affiliates, the claim of the Research Affiliates case was claim number 3 that we looked at a moment ago. All right. So who's correct in this whole debate? Now, in considering this question, I've identified 3 positions. Now, of course, this is a generalization, but we've got the patent attorneys who are trying to get patent applications accepted and being shouted at by the clients if they're not. We've got the delegates who are making decisions, and we've got the examiners who are examining these applications. So this is a generalization, but what patent attorneys are saying is that anything done by a computer is patentable. So I'm quoting from a blog of a well-respected patent attorney. It says, until recently our advice to clients was that business methods were patentable in Australia, provided that the claims were limited to execution of the business method in a computer environment. Okay? Then we've got the delegates who said, right, enough is enough, no more tech washing. You can't simply make something non-patentable patentable by adding a computer. And in fact, if you put a computer in, we're going to take it out again and look at what's left. And we're not going to be bamboozled by your fancy claim language. We're going to look at the specification rather than the claims to figure out what is the substance of the claim. And if that's a business method, we're going to refuse your application. And then lastly, we have the examiners. They're on a witch hunt. They're looking for business methods. If your claim smells like a business method, it'll be refused. So method claims are routinely refused. Okay, so in the middle we've got this question mark, and I believe that the Research Affiliates case will settle the issues here, and we'll be left with something in the middle. Now, I say in the middle because I don't believe that any of these positions are correct. While the patent attorneys and the delegates both have an element of truth in them, I think the decision will lie somewhere between them, but there really is no support for the examiner's position that business methods are not patentable in Australia. Okay, so while we wait for the Research Affiliates appeal, or the appeal to the court, let's turn to the authorities. Now, the first port of call is considering the Patents Act. So what does the Patents Act say? the Patents Act says you can patent something if it's a manner of manufacture. Okay, so straight away you think, okay, we have to manufacture it, it has to be physical, it has to be something done by an industrial process, so it has to come off a conveyor belt. But this isn't necessarily so. When you consider where these words came from, these words were formulated in 1624. So this was done by the English Parliament to take control away from Elizabeth I and James I, who were abusing the latest patent system by granting patents for salt and sugar and common household items. Okay, so these words, manner of manufacture, still judge modern technological advancements in Australia. So what it tells us is that we shouldn't be looking at the Patents Act. We should be looking at court decisions to interpret what these words mean. Okay, so this allows the Australian Patents Act to keep up with developments in technology, which is one of the great strengths of the Australian Patents Act. It's adaptable. Okay. So if the Patents Act isn't going to tell us what is and what isn't patentable, let's turn to the court authorities. So the first one I mentioned was the NRDC case. This was spraying crops in a certain manner to result in a weed-free tract of land. Okay, it was considered a watershed case because it's visionary in what it judged was patentable and what wasn't. Before this case, the test was whether you could sell something, the vendible test. So if you could sell something, you could patent it. But here they said something is patentable if it offers some advantage which is material in the sense that the process belongs to a useful art as distinct from a fine art. Okay, so I'm just going to dwell a bit on these words. So it's important to analyze each of these words because I think subsequent decisions have deviated away from what was said in this case. Okay, so first of all, it must offer some first advantage, all right? So this is our first clue that we're looking at the result, okay, not the actual embodiment. Now in this case, there arguably was no embodiment. Spraying crops, there's no physical embodiment, but what it results in is the weed-free tract of land. Okay, so the embodiment doesn't matter. The result does. So to use a silly phrase, what is important? We're looking at the sausage, not the sausage machine. Okay. Then the advantage must be material. Now note that it doesn't limit it to being physical, and it's got to be distinct from fine arts. So no pure artistic expression. So no paintings or sculptures, etc. Okay. So that was that NRDC decision was summarized nicely in the CCOM case, where they said that something is patentable if it's a mode or manner of achieving an end result which is an artificially created state of affairs of utility in the field of economic endeavor. So again, I'm going to dwell on the words. So where it says a mode or manner, okay, so instantly you can see that it doesn't have to be physical. Now this is important when we discuss the patent attorney's position saying that putting a computer in something physical will get you patentability. Here it says it doesn't have to be physical, okay? And we're looking at an end result. Again, we're not looking at the embodiments, we're looking at what pops out. And we're just looking for an artificially created state of affairs. So again, no physical output is required, okay? So from CCOM, we've got a great two-pronged test to judge whether things are patentable or not. We're first looking for practical application or utility, something that's not a purely mental act. And we're also looking for commercial or industrial applicability, so not pure artistic expression. Okay. Then lastly, we have Grant. Now, in this case, Mr. Grant tried to patent an asset protection method. But even though this claim was held not to be patentable, it gives us some valuable insight into what is and what isn't patentable. So on the right-hand side, we can see that the court said that business methods are not unpatentable. All right. So it doesn't matter whether you can call something a business method or not. The test is whether it is a manner of manufacture, irrespective of the field in which the technology lies. So the test is, does it result in something useful? Okay. So Grant went on to say on the left-hand side that things aren't patentable are things without effect. All right. So mathematical algorithms, mere working directions, pure information. So in summarizing these three court decisions, it's very important that we distinguish in our minds the distinction between the embodiment of the invention and the result. Okay, so the embodiment isn't necessarily relevant. It's what it results in. Now, is the result a manner of manufacture? So is it practical? Does it have commercial or industrial applicability? Okay. Okay, so what we're going to do here is just apply what we've learned from these three cases to other cases that have been held to be patentable. So all of these cases here state of affairs. So right at the top, we have electrical oscillations. That was held to be patentable. That was in 1947, the Ranson's application. Then going clockwise, we have the weed-free tract of sown land. That's NRDC. That was the result. That was useful. We have a fog-free atmosphere in the Alton and later chemicals application, 1957. Moving down, we've got a fire-quenched subterranean formation. That's a cementation codes application. And now we've just got three computer examples. We've got, at the bottom left, producing a curved image. That was the IBM case in 1991. Then moving up, we've got the retrieval of the graphical characters for the assembly of text. That was the CCOM case in 1994. And then the last one is the welcome real-time of tracking shocking behavior by writing to a behavior file. So these things resulted in something. So just to, by way of comparison, here are some cases of things that were held not to be patentable. On the right-hand side, we have a method of producing an asset using trusts. Okay, that was Grant's application in Australia. On the left-hand side, we have hedging losses in the energy industry by investing in other segments of that industry. Okay, so that was the Bilski Kappa's case in the United States. But see how hard it is to draw the result. How do you draw a protected asset? Okay, so these claims, rightly so, were held not to be patentable because they don't result in anything. Okay, so what about computer application? So here's just a diagram of, this is the Diamond Vestia case, the US case in 1981. So just to place in your minds the distinction between whether it results in something, and especially with a computer application, because this is a live issue when it comes to software-related applications. On the right-hand side, if you have a computer for simply calculating the Arrhenius equation, that is something that's not patentable because it's not applied, it's something that doesn't have commercial or industrial applicability. However, if you have a process for curing synthetic rubber by calculating the Arrhenius equation by using a computer, that is something that is patentable. Okay. So for another example, you can't get a patent for a computer for calculating the cosine of an angle, but you can get a patent for tracking the trajectory of a ballistic missile using the cosine of an angle. Okay. All right, so that was a summary of what the law says. So hopefully what you should have taken away from that is we're distinguishing between the embodiment and the result, and is the result a man of manufacture. So let's revert to our three positions and discuss what each of them said. So first up is the patent attorneys, who say that anything done by computer is patentable. Okay. So on the left-hand side, we've got some arguments for this position. Okay, so in the Grant case, it was said that a change in state of information in part of a machine, so for example, writing to random access memory, that was held to be the physical effect. In the Welcome case, writing to a behavior file, that was held to be a useful result. Okay. And then at State Street, on the left-hand side, which is a US case, writing a final share price to memory, that was held to be something that was patentable because that was your useful result. Okay. However, we should put this in context. Now we're moving across to the right-hand side to consider the arguments against this position. So first up in Australia, we must qualify that in that case it said things without effect are not patentable. Okay. Now I couldn't find an Australian authority that said you can't tech wash anything to get a patent, but we've simply got to look beyond our borders to similar patent jurisdictions, and we'll see that the writing is on the wall. So first up, we have Bilski. It says the prohibition against patenting abstract ideas cannot be circumvented by attempting to limit the use of the formula to a particular technological environment. Okay, so Bilski says you can't make something patentable by simply putting it in something technical. Then we have the Diamond Vestia case that says insignificant post-solution activity will not transform an unpatentable principle into a patentable process. And then lastly, we're talking about the Amazon one-click case. Now this is the Canadian case, which we'll discuss later. But it was quite succinctly put in the appeal that it does not necessarily follow that a business method that is not patentable because it is an abstract idea suddenly becomes patentable because it has a practical embodiment, because it is axiomatic that all business methods always have or are intended to have practical application. Okay, so I think the writing is on the wall here. No more tech washing, so there's 1 point for the delegates. Okay. Right, now let's consider what the Australian Patent Office, the Commissioner's delegates are saying in the Australian Patent Office decisions. Just to put this in context, this is the claim of the Invention Pathways case, which was the first of the business method smackdowns. Okay, and we'll be discussing the distinction between the embodiment and the result. So this was a system for commercializing inventions. So it's got a couple of steps. So you apply for a patent, then you do a review, then you do some R&D, then you do some prototyping, then you do some product positioning, then you do a manufacturing checklist. And then once you've done all of those steps, you put them in a checklist, and then you complete. Then you police compliance. Okay. Okay, now we're going to talk about the three arguments that the delegates put forward in this and subsequent cases. But it was argued in this case that the checklist was the effect of this patent. Okay. Now the delegate took a dim view of this and said, look, the checklist is incidental to the rest of the invention. All right. Commercializing an invention, you don't need a checklist. So what he did is he struck out feature G and then said, well, what's left? That's a business method. Okay. The delegate said in this case, the concrete effect or phenomenon must be one that is significant, both in that it is concrete, but also central to the purpose. Okay. And this was summarized in the subsequent research affiliates case, where they said a physical effect that is peripheral or subordinate to the substance of the claim is not enough. Okay. Now the delegate didn't stop there. He used this argument as a springboard and carried on to say, I consider the same thing to apply to business methods. Okay, and patentability doesn't arise from the fact that a business method is implemented in a computer or some other physical device in an incidental way. So what the delegate there is saying is that computers are merely incidental. Okay. So the delegate gives an example saying, well, a step of building a house involves a concrete physical effect. It is peripheral to the method of acquiring a house. Okay, sounds convincing, right? But I think it's wrong. Okay, what we've got to distinguish here is the embodiment and the result, the sausage machine. The electronically fillable checklist. Okay, that's the embodiment of the claim. It's not what results from doing this claim, or from working the method. Okay. Now, can you imagine what would happen if the delegates or the examiners could simply read out elements of your claim when it came to novelty, for example? I mean, there would be an outcry. So why can you do it for patentability? Okay. So it's unfortunate that this assertion was made that computers are merely incidental, because I think it sent examiners off at a tangent. In the next example, you'll see how if you file a computer-implemented claim, what the examiners do is they take out the computer and say, what's left is a business method. Okay. So these are the first two arguments that the delegate has said, that peripheral things are to be excluded, and when it comes to software or computer implementation, the computer is merely incidental. Okay. Another problem I have with this is that I think the delegate goes too far. The NRDC case said that to get patentability, it must result in an artificially created state of affairs. I think here the delegate has introduced what I call a patentability threshold, kind of like an inventive step threshold. Not only do you have to have an artificially created state of affairs, it can't be peripheral, it can't be subordinate, it can't deviate from the substance of the claim. Now, all of these are very subjective terms. We've got no means for measuring or determining how to judge these terms. They're all subjective, and it gives the examiner a big club to knock back applications, saying, yes, your claim results in something, but I don't think it's substantial enough. Or what it results in, I think, is peripheral. Okay, now, this isn't supported in the law. The last thing that the delegate does is they take the substance over form approach. So they look at the substance of the specification as opposed to the claims. Okay, so this is what is said in the case. It says that is, the application disclosure should be considered as a whole, and care should be taken not to allow the form or words used in the claim to cloud the real issue of manufacture. Okay, so are the alarm bells ringing? This is incorrect. Okay, the specification, according to the delegates, the specification defines the invention. Okay, if the delegate was correct, we might as well just file a specification, and the examiner can work out what is the invention. All right. Section 40 says that the claims define the invention, and the claims are to be construed in a purposive manner by a person skilled in the art. Okay, so to use a silly example, imagine you filed a specification for a jet engine that reduced fuel consumption by 20%. The examiner could come back and say, oh, the specification is a business method for saving travel costs. It's a ridiculous example, but it's no different to what the delegate is doing here. Okay, and this is very important to realize the substance of reform approach, because this is what happened in the Canadian one-click case, which we'll discuss at the end. Okay. Finally, we come to the examiners. They say that business methods aren't patentable. Now, if you look to your notes on page 18, there's an example of a refusal that I received for an ITS. Now, an ITS is an international type search. It's kind of a sneak peek to novelty. But the examiner refused to search our claim because he said it wasn't patentable. So I'll just read what the examiner said. Now, bear in mind that this is the unfortunate position that I was talking about, where examiners exclude computer implementation and look at what's left. Okay? So the examiner says, all of the steps involved in the current invention are directed to a mere business scheme. The use of a computer to store data, generate the message, encrypt and decrypt data is considered to be incidental or indirect and does not change the core, the substance, of the invention, which is a mere scheme or presentation of data. Therefore, I believe the current application contains no patentable subject matter. Okay, so in the entire refusal, the examiner didn't mention the effect or mention NRDC or CCOM. And to add insult to injury, despite not doing the search, they only refund half of the $1,400. So what has the examiner done? The examiner has excluded the computer as being merely incidental, so he's sliced your claim up like a fruit salad, taken out the computer, and looks at what is left, or what has been added or discovered, and is what's been added or discovered patentable, or is it technical? So for example, is it technical or is it a business method? Okay. Now, again, this is important because this is almost exactly what happened in Canada, okay, in the one-click case. So let's discuss this case. So why are we discussing this case? First of all, Canada has a similar Patents Act to Australia, defines the invention. Unlike our European counterparts, where the European Patent Convention has a set of exclusions and doesn't define the invention. In the Australian Patents Act, we've got manner of manufacture, and we've got a similar definition in Section 2 of the Canadian Patents Act. Okay, and also the facts of the case were similar to what we've seen done in Australia. There was a unilateral change by the Canadian Patent Office, and one of the cases which they refused, which was the Amazon one-click case, got appealed. Okay, so some of you may know the Amazon one-click case was a technique for streamlining ordering on the internet. So what it does is it keeps your credentials in a cookie, so that if you come back for a repeat purchase, you don't have to re-enter your credentials and billing information, credit card information, and so forth. Okay. So what did the Commissioner do? The Commissioner said, the Commissioner took the form and substance approach and excluded the computer as being merely incidental, saying computer systems are known, let's rip those out. And what was added or discovered? Well, what was added or discovered was a method of streamlining ordering. This is a business method. It's not patentable, it's not technical, and that got refused. Okay. So Amazon appealed this to the federal court. And Mr. Justice Phelan disagreed with the Commissioner, and this is a summary of his findings. He said in Canada there's no tradition for the exclusion of business methods. Okay, so that agrees with the Grant case in Australia. He rejected the form and substance approach, so he disagreed with the research affiliates. You can't slice and dice and take out computers and exclude features that are considered to be merely incidental. He said the claims define the invention, and the claims are to be construed in a purposive manner. And a purpose of construction of the claim disclosed a machine, which was something which is patentable. He also said that the technological requirement is too restrictive, and he emphasized again that when we're looking at the end result, we must focus more on the practicality rather than the physicality of the end result. Okay, so I couldn't summarize this dim view, so I've just put it up here. He was not impressed with what the Commissioner had done, so he said, the absolute lack of authority in Canada for business method exclusion and the questionable interpretation of legal authorities in support of the Commissioner's approach underlines the policy-driven nature of her decision. It appears as if this was a test case rather than an application of the law. All right. So the Commissioner didn't like being told off like that and appealed it, so it went to the Federal Court of Appeals. But the Federal Court of Appeals in Canada basically agreed with the Federal Court. They just qualified that the purpose of construction should be done by the person skilled in the art, and they reaffirmed that you can't simply tech wash, and that's that quotation we saw earlier. So the patent was referred back to the patent office and it was granted. Okay. So in light of that Amazon one-click case, what do I think the outcome in Australia will be as a result of the research affiliates case? I think it will be reaffirmed that there is no exclusion to business methods, okay? So there we have one point for the patent attorneys, okay? Second of all, I think that it'll be form approach is wrong, okay? The claims define the invention. You can't exclude integers or the entire claim for the purposes of assessing patentability. All right, so there we have 2 points for the patent attorneys. I think it'll be said that a mere practical embodiment is insufficient. Okay, so no more tech washing. 1 point for the delegates, and the test remains as per NRDC. Does it result in something which is a manner of manufacture? So no points for the examiners there. So tips to avoid refusal while this uncertainty prevails. When it comes to the prosecution of your patents, we think you should take a defer and delay approach. Delay prosecution until sanity prevails. When research affiliates sets things right, then jump out of the reads, request examination. You may even decide to take the innovation system, the innovation patent application approach, and those are applications that are not examined automatically unless you request it, so no one will ever say that it's not patentable. When it comes to drafting, you should draft your claim so that they result in something. So if you get stuck in an argument with the examiner, you can say, this is what pops out of my claim, that's the artificially created state of affairs. Realize that computer implementation is not enough. Okay, so here's a sample claim, if you can read it, which I propose for the invention pathways case. So what I've done is I've tech washed it. Of course, I've said that this isn't necessary, but we've seen that examiners, when they see a method claim, they're quite trigger happy in rejecting that. So we've got a computing device. Now in the preamble you can see I've put the result for generating invention-specific non-compliance notification data. Okay, it doesn't have to be physical, but data gives it a nice feel, convince the examiner. We've got a processor, memory device, and a data interface all tied together. This isn't necessarily limiting. If your invention has to be done by a computer, all computers have a processor, memory device, and a data interface. Okay, and then we've got some steps done by the processor, controlled by the computer program code. So receive via the data interface, and I've just made this up. So filing date of a patent, calculate one or more steps and associated dates for the completion of those requirements. Receive via the interface compliance data representing compliance with these requirements. Do some more steps, and if any of them aren't ticked off, send non-compliance notification data representing non-compliance with at least one requirement. Okay, so you can go to the examiner and say, there is my artificially created state of affairs. So that's a summary of my talk. I hope I've given you an overview of how to approach deciding whether or not something is patentable, and I fully expect that we will get some clarification from research affiliates later in this year. So things will be put to bed and put back to the way they were. So.